Welcome everyone to COVID-19 in the workplace, hot topics as California gears up for reopening. Thank you to the Beverly Hills Bar Association and the Labor and Employment Law section. We hope that this is going to be a dynamic program that you're going to learn a lot from, especially now that everything is changing. Employment is starting to open up, stores are starting to open up. Hopefully soon we will get back into the world of the living, although it'll take some time. Things will never get back to normal, and anyone that thinks that it is should go back to sleep and continue dreaming. But welcome everyone. Here we have a group of talented speakers. We start with LaVon Lawson. She is the tax attorney of the law offices of LaVon D. Lawson. She represents individuals, entities in federal and California state tax matters. In addition to operating her own practice, she's also of counsel at a law firm in Irvine, Albrecht and Barney. She previously served in the executive committee of the California State Bar Taxation Section and is the former chair of the Taxation Section's Tax Procedure and Litigation Committee. She is also the immediate past president of the Beverly Hills Bar Association. So let's welcome him on. Next, we have Jeffrey Bills. He's a defense attorney of the law offices of Jeffrey C. Bills. He focuses on employment litigation throughout his legal career, including single plaintiff, wage and hour class actions, pay gap litigations, as well as traditional labor. He advises clients on issues including COVID-19 laws, WARN Act, Mini WARN Act, wage and hour law, job classifications, workplace compliance, litigation avoidance. He also conducts workplace harassment prevention training, and he is the chair of the Beverly Hills Bar Association Labor and Employment Law Section Executive Committee. Welcome, Jeff. And next we have Christopher Dolan. He is a plaintiff's counsel from the Dolan Law Firm, where I also work at. He's recognized as one of the top plaintiffs lawyers in California, founder and chief legal counsel of the Dolan Law Firm. He spearheads significant and challenging lawsuits across the state of California in federal and state courts against insurance companies, Fortune 500 companies, and other public agencies and product manufacturers. He also has one of the largest verdicts, $61 million for individuals subjected to racial and ethnic discrimination and harassment in violation of their civil rights. Welcome, Chris.
Hello, everybody.
Well, hopefully you all will learn something this afternoon. In case you have not been in a coma for the past 5 months, you have all heard of the coronavirus. So we're going to be discussing some topics that will be relevant to your job. Let's go to slide number 4. So we're going to be talking about COVID's impact and businesses' reactions, relief programs for businesses, tax implications for relief strategies, relief programs for employees, working remotely, returning to work, anticipated litigation, the practice of law, and now we're going to begin. Well, we've had a couple of declarations in the state of emergency that we've been in. As you can see, our governor, Gavin Newsom, and our mayor, Garcetti, on March 4th declared a state of emergency in the state of California, and we started to advance towards where we are now, which is the stay-at-home orders. It wasn't until March 13th that the national government, with Donald Trump, issued a state of emergency for the country. So we've been in ever-changing developments that we've had to adapt to. So now Jeff is going to talk to us about the reaction to the disaster and how businesses had to react.
Well, shortly after some of those emergencies that Lourdes just discussed, there was a great deal of uncertainty about what ought to be done, and that was clouded to some extent by the legislation that came out. On March 18th, one of the most important pieces of legislation, the Families First Coronavirus Response Act, FFCRA, was enacted. A day before that, Governor Newsom put out an executive order that gave some relaxation to some of the WARN Act requirements, requirements that otherwise are required under federal WARN Act and mini WARN Act laws, that employers give notice in advance of a plant closing or mass layoff, depending on the size of the employer. What happened during this time was a lot of businesses really weren't sure what to do. The FFCRA was clearly going to give a lot of important benefits not only to the employees but also employers in terms of paid sick leave and family and medical leave. We'll talk more about that in a little bit, and tax credits for the businesses that did this. But it wasn't clear when this law would go into effect, what benefits people, whether people who got the benefits would qualify under this law. Everyone kind of assumed it would go into effect April 2nd, but on the face of the legislation, it was left up to the Department of Treasury to decide during this 15-day period after enactment, and it turned out to be April 1. So even now, in terms of compliance with WARN Act, compliance with FFCRA, eligibility, there's still some unanswered questions. The good news is that as we go into reopening, it appears there's going to be an opportunity to learn from some of what we've seen and plan out, hopefully, what we can do now as we face potentially additional need for these benefits or possibly layoffs. However, there were some pitfalls that people may have fell into, and I believe Chris is going to take us through some of those.
So one of the things that we're finding as a plaintiff's law firm is that we're seeing an uptick in calls from people who believe that they're being selectively deselected from the workplace, and that they're being laid off or fired because they fall into a category of employees that may be older, disabled, or people that are taking leave, or someone, for example, if they've had a family member who had COVID, that they may be getting pushed out because of a concern that they may infect the rest of the organization. So in terms of doing any type of a reduction in force or layoff, people need to be very conscious about not using it as a house-cleaning tool for people that may otherwise have protection, because people like me are getting calls to see if this is being used as a pretext for wrongful termination. Levon, I believe this is you to begin talking a little bit about tax implications for some of the relief programs.
Sure. So it depends on which relief program, Jeff, we have. I don't know if we want to talk about the relief programs under the FFCRA and talk about that, and then the credits associated with it.
Why do we come to that a little bit later? I just thought perhaps you could tell people some of what you'll be discussing as we go through this, related to the tax implications, with a high-level overview of what we'll then be discussing on a more micro level.
Absolutely. So with respect to employees, I think as people know, there has been expanded unemployment as well as pandemic unemployment assistance for those people who would not normally receive unemployment. There are also, and there are tax implications with respect to that. There's also workers' compensation. And we'll be going through that. On the employer side, we'll be talking about kind of the tax implications available to those people, for instance, who receive the Family Leave Act payments and the sick and medical leave payments, and ways that the government is coming in to provide credits for those. There are also credits on the employer side for employee retention credits to help employers try to keep people on their payrolls as opposed to putting them on to unemployment. There are also certain tax deferrals. And then later on, we'll also be comparing some of the relief programs, including the PPP program, of which people are very aware, and in some other SBA programs, mainly also the emergency relief loans as well, and comparing those and looking at some pitfalls or things that we should take into consideration along the way. So who's is going into for employees? I don't know if we were going to talk about, I don't have much to say.
So I'm going to talk about as it relates to the relief for employees.
Okay.
Because part of what we want to do during this is we're talking to people we understand who are employees of law firms. We're talking to people who run sole practitioners, and we're talking to people who run law firms. So we're trying to give a little bit of something for everybody here.
Wonderful.
So we know that a lot of our colleagues have been affected by COVID. I know of layoffs that have occurred in law firms, unfortunately, or where there have been reductions in hours, or there have been furloughs. So I want to talk about some of the programs that are available and provide relief for the employees. And one of them is a very interesting phenomena that has we've now seen in California, is that under the workers' compensation law, pursuant to Governor Newsom's executive order N6220, there's now a presumption of workplace injury. If someone tests within 14 days after working at an employer's direction out in the public for any day after March 19, where they're not working from home, and this presumption is rebuttable. So this applies to everybody, insurance carriers, self-insured employers, the state of California. And an individual has to, if they're going to seek this presumption, get a certificate of disability by a medical doctor within 15 days of diagnosis and every 15 days thereafter. So it's a radical change that the governor's put in place to say that if you have COVID, it's presumed to be in the workplace as long as you are working. Now, interestingly enough, it's been yet to be determined how does that apply to people that are teleworking. The employer, you see here, the place of work is not your employee's residence. So it can't be from your own home if you get it, because you can be affected by someone in your household. But if you're going to a court appearance, if you went to get documents at the office and came in contact with people, or you're having to see clients, then you may have this presumption in your favor. And someone on the chat asked, would these slides be provided? Yes, they will be provided, as well as a host of resource materials that we have on these subjects, including the executive orders and you'll see later some of the documents pertaining to reopening and how to reopen safely. So Levon, can you talk a little bit about
Can I if I could just interject one thought on the workers' comp. One benefit, one effect of this might be that it provides a little bit of cushioning against lawsuits based on negligence or wrongful death, to the extent that these are going to be within the workers' comp system instead and subject to that exclusive jurisdiction.
Why'd you have to go and bring that up? That's a bummer.
Well,
Keep that to yourself, will you?
Chris, I have a question on that. What, as an employee, what can an employee do if they find that their employer is not complying with what they need to be doing to keep them safe in the workplace if they have to be there? For example, grocery store workers.
So we'll be addressing some of that later on as it relates to what the employer obligations are and what the employee rights are, and some of the issues that pertain to what can happen to employers who may retaliate against employees. So we're pinning that a little bit at the end of the program, and I will put a pin in that for now. How's that?
Sounds good.
So with respect to kind of the taxable effects of workers' compensation payments are typically not subject to taxation. There is, except to the extent that there is some a person is receiving also certain supplemental Social Security or supplemental income payments. So for workers' comp, typically I just don't see a lot there. This is interesting. I don't know if this though, where more is presumed to be subject to workers' comp, if that kind of allows a person maybe to receive certain relief before they start going into taxable relief. I don't know, but there's not a whole lot for workers' comp, actually.
So we're going to talk about different programs that are available to people who have been sick as a result of COVID. And they are layered. So it gets a little bit confusing between what the states are doing and what the feds are augmenting, and whether it's constituted as sick leave or it's constituted as medical leave. And it will be pretty much something that will follow a timeline where one leaves off and the other picks up, except for this particular aspect of it. So people may not know it, but for every 30 hours that you work, you pick up 1 hour of paid sick leave under California Labor Code Section 246, as long as you've been employed for 30 or more days within a year. So you can accrue up to 24 hours or 3 days of sick leave that can be used in 2-hour increments after the 90th day of employment. And it can carry over if you don't use it from the previous year, but it doesn't have to, no obligation to go over 6 days, and an employer can say you have to use it all in one time period. Now, this can become helpful to people who are going to be going through the following, which is the supplemental sick leave for employees and the supplemental COVID sick leave. So the supplemental sick leave for food service workers is for people who are working out and farm working or transporting foods. Interestingly enough, they put down transportation network carriers might qualify under this because they are providing delivery in the food chain. But the governor's executive order on April 16 on 2020 provided for 80 hours of COVID supplemental sick leave if someone was 6 times full time. So they can get up to 40 hours per week for 2 weeks at their regular rate of pay, or at least at the state or local minimum wage, with a maximum of $511 per day, or I think I can't read on my screen, but $5,110 in the aggregate. So this is new. This is specifically because of COVID to help people. And I think that the 80 hours was primarily designed because of the fact that they were saying COVID's like a 2-week process for a lot of people to get sick and get better.
I just have a couple thoughts on that too, if I may, Chris.
Yep.
Paid sick leave is complicated in any circumstances. In addition to the state requirement, a lot of local cities and local jurisdictions in California have their own additional and often different paid sick leave ordinances. And those are they all need to be taken into consideration as well. And even when it comes to some of this emergency paid sick leave for COVID, there are cities within California that have done some things. When it comes to making sure that employers know what all the benefits are, it's good to consult with counsel.
Yeah, in San Francisco, there's a different program as it relates to San Francisco, what they call Healthy San Francisco. So you have to look at the federal, the state, and the local as you go through. Now, Levon, I'm curious, sick leave, is it taxed as regular income?
Well, yeah, it's going to be taxed. And what's interesting, I'm curious as to how these different payments are layered in terms of if you have relief from the city, relief from the state, relief from the feds. But pursuant to the Families Leave Act, there is a tax credit, a refundable tax credit that is available to people who are, rather to employers. You know what, let me step back because there's two sides of this. Yeah. So for people who receive the leave, it is going to be treated as compensation, and the employer should be withholding, just with respect to other forms of compensation. Should I talk about the credits now, or talk about the credits?
Let's get to that in a moment if we can. So you're right, it is kind of complex and it's layered. And the thing that they've done to streamline it all is that it's all being processed through the State Department Employment Development Department. So it's a one-stop place to get your sick leave, to get your medical leave, to get your emergency COVID medical leave, to get as we'll see, some of the increased compensation that the feds are providing. So you're not going to 2 agencies. It's going to be administered through one agency, which is the Employment Development Department in California, if you can get through on the phone. I understand that.
Good luck with that.
Yeah, I understand that's like trying to get a ticket at Hamilton. So we'll go on now to a discussion about some of the unemployment benefits. Levon, if you want to take that over, I'll just click onto our screen.
Sure. I think Jeff and I think we were both going to talk a little bit about that. But I think what's kind of really interesting is that for the first time, in addition to unemployment benefits being available and having been expanded, there's also pandemic unemployment assistance, which started up sometime in April. And this was the first time that actually business owners, independent contractors, gig workers are also able to take advantage of unemployment assistance programs. For the pandemic relief program, I think that the only way to apply was online. And while I understand it was difficult, I'm aware that people were able to get through. What's a little bit, I think people are very aware of, is that there has been an enhanced payment provided by the federal government for unemployment and pandemic assistance, unemployment assistance, of an additional $600 over the basic payment. So for unemployment and as well as pandemic unemployment, there's kind of a basic unemployment payment there, and there's the additional $600 per week, which is available until about July 25th. And then after that, people can apply to get continued unemployment assistance pretty much to the end of the year, but it would be at their basic payment, unless there are further changes that are made going forward, which is quite possible.
One interesting element of this too that we may have touched on briefly is self-employed individuals can now get unemployment benefits. The mechanism in California for that to be available through application didn't come until a little more recently. But that's super helpful for attorneys, for example, who have been self-employed, might not otherwise have been even eligible to apply. Now it's possible.
The other thing is that, I mean, the government was very wide-reaching, and let's be clear, it wants to keep people in their homes so that they're not out getting infected or worried about housing during a crisis of health. But it also wanted to get people off the streets by not feeling like they had to work or starve. And the third part was to inject money back into our economy. So these are as much stimulus packages as they are relief to individuals. And there's some other programs on top of this, as people have heard about the $1,500 deposited into people's accounts if they made below a certain threshold. And even in California, the governor has a system through a proclamation whereby people who are not legally within the country and can't demonstrate that they have the right to work can receive up to $500 worth of assistance and up to $1,000 per family through Catholic Charities. So the state of California has gone one step beyond continuing the unemployment. And one final thing on unemployment is if anybody's already exhausted their unemployment because of a previous claim, they can apply for the pandemic emergency unemployment compensation and get benefits even though they otherwise would have been timed out of the system.
Yeah. And these payments are going to be includable in income. So people I think there's the opportunity to withhold on the payments that are made for the unemployment assistance. But something that you referred to, Jeff, that I just wanted to comment on real quick. I think you were commenting on the stimulus payment that went out from the feds, and that would have been $1,200 per person, $2,400 for $1,200 for a single filer, $2,400 for joint filers, and $500 for each qualifying child. And those kind of start to phase out for individuals once they start making over $75,000, phases out by the time they're up to $99,000 in AGI, just a gross income. But yeah, there are a number of payments out there trying to, like you said, inject monies into the system.
Yeah, I got those numbers wrong. I said 1,500, but I guess I should be happy to say that I didn't qualify. And let me ask you this, are those taxable benefits, that injection money, is that considered income? Is it a gift? What is it?
You know, it's interesting because it's treated as a refundable credit on our 2020 filing. That's a great question. So they based it on whatever your most recent filed return was. So either your 2018 or 2019 return, based upon the adjusted gross income, they made a determination as to whether you could get a stimulus payment. And those went out, but they're treated as refundable credits on our current tax year. So I'll be honest, I'm not quite sure if it will come back into income. It probably will depend on the income for the 2020 year.
So Jeff, I think this goes over to you.
Sure. These are some of the benefits that we mentioned at the very top of this webinar arising out of the FFCRA legislation. We have some additional paid sick leave benefits that Chris has described, as well as some family leave benefits. And it's a little bit, it's an interesting organization of qualifying reasons for leave connected with the type of leave available. There are basically 6 different qualifying reasons for leave. I don't know, we'll go into all the details, but generally speaking, the employers who are covered by this are going to be private employers with fewer than 500 employees, affecting interstate commerce, and public agencies with 1 or more employees. There are these paid sick leave benefits, as Chris, I believe, described earlier, the 2 weeks of paid sick leave for all employees. This is at the employee's regular rate of pay, where the employee is unable to work because of the employee is quarantined, pursuant to a federal, state, or local order, and or experiencing COVID-19 symptoms and seeking medical diagnosis. There's another 2 weeks of paid sick leave available up to 80 hours at 2/3 of the employer's regular rate of pay, because the employee is unable to work because of a bona fide need to care for an individual subject to quarantine, or to care for a child under 18 whose school or child care provider is closed or unavailable, or if the employee is experiencing a substantially similar condition as specified by the Secretary of Health and Human Services. That's a little vague area. A lot of this is developing law. To get into the weeds, it would probably take longer than we have in this webinar. And then we have the additional 10 weeks of paid expanded family and medical leave, which is available for at 2/3 of the employee's regular rate of pay, where the employee has been employed at least 30 calendar days and is unable to work due to a bona fide need for leave to care for a child whose school or child care provider is closed or unavailable. So these all interact with each other. As to the FMLA leave, one thing that's kind of interesting is it doesn't provide any additional weeks of FMLA leave. So if someone has exhausted their FMLA leave, they don't get more weeks. However, it does provide additional reasons, and there's additional provisions related to this kind of leave. Some of those are available in the handouts that accompany this webinar and that will be distributed.
So one of the interesting things that I noticed while we were all researching this together was the way in which there's a differential in pay for people who are caring for someone who has COVID or is taking care of children and unable to work because of school closure, where they get $200 a day, which interestingly enough, I think is kind of an institutional continuation of gender discrimination, because many of the people who are caring for children at home and providing schooling are mothers, because I can tell you I'm ill-equipped to sit down with my kids and go over Common Core math because I want to throw it out the window. But I do notice there is a bit of what I thought to be a little bit of some inherent discrimination in this. And the other thing that I think people should know is that with both the sick leave and the FFCRA, the time doesn't have to be all taken at the same time. It can be intermittent. You can take it, in days, half days. For sick leave, it has to be minimum of 2 hours. And Jeff's going to talk to you a little bit about what the employee responsibilities are before Lavon gets to tax. But Lavon, did you have something you wanted to add on this?
I had a question actually about how those layer. So for instance, you have the sick leave, whether you're ill or whether you're taking for care of someone else. And then for the family leave, there's a period of time that's unpaid
Yeah.
before you go paid. How do you layer all of those?
So the sick leave gives you the 2 weeks, and the family leave picks up after the 2 weeks.
So you have to go for 2 weeks of unpaid, it sounds like, between the sick leave and the family leave?
No, you get your 2 weeks in sick leave, and then you'll roll into your family leave right after that. But you may be able to take, it gets a little complicated because you may be able to use some of your own vacation or sick time to augment the amount of money that you're supposed to be paid so that you can keep your salary level up. But it's designed to roll you from sick into family medical leave, like we often see people roll from unemployment into disability. The sick leave, the nice thing about that is it's not affected by how much family leave you've already taken, and it gives you that benefit. But it's so they layer in that way. But again, one of the good things is it's all being administered through the Employment Development Department. So if you can get through to them, they're supposed to guide people through under what they qualify. And you can actually switch your pay rate depending upon whether you were sick and got better and now your kids are off from school. Your pay rate can fluctuate depending upon your status.
Okay.
So
That's
Jeff,
standard.
did you want to talk about employee responsibility?
Sure, I'm happy to do that. You know, getting back to the intermittent leave, I believe that there are some intricacies to that as well as it relates to teleworkers. And, you know, again, it's an area for business owners, for employers to talk with counsel. But this is not the kind of benefit that employees get just without just on their word. There's document that the employees also have obligations and responsibilities. The employer is permitted to request, and in fact has to request and retain for 4 years, documents that support the certification for leave. And this information includes, for example, the COVID-19 qualifying reason for the leave, a statement that the employee is unable to work, etc. This should be this needs to be provided to enable the employer to properly give this lead. And this slide includes a little example regarding the telework aspect of this. An employer can require telework if the employer is capable. And there's the Federal Register. I think, Chris, you put this together, gives a little example.
This was the example they gave. I thought they wrote it for our presentation. It's on law firms in teleworking.
Mm-hmm. Yeah, so if a law firm permits its lawyers to work from home, a lawyer would not be prevented from working by a stay-at-home order and thus may not take paid sick leave as a result of being subject to that order. Anyway, I'm sure everyone saw the rest of it.
So I think what's important to note is that people don't get to take time off for caring for a child or caring for somebody else if they can work remotely. And telework is a little bit broader than Zoom work. It's just being able to work in a location using some technology other than your normal place of work. So if there is work available and can be done, employers can say, you don't get the leave because you have work available. The other thing that comes up through all of this, and we're seeing now with the $600 increase in payments, that some people are choosing not to go back to work because they feel that they're doing pretty well with this extra $600 bonus, and they're frightened to go back to work. And so they're saying it meets my needs. But if the employer opens back up and makes work available, and you don't have another qualifying reason that we'll talk about later not to return to work, then people have to return to work or they may be denied their ability to get the benefit that they want to have. So, Levon, I think who's next, Lourdes?
It is Levon.
Okay. Does this
Anytime you see the word tax, it's pretty clear that it's up to you.
Always Levon.
So, they've mentioned, Jeff and Chris described these relief programs, certainly that were provided pursuant to the act where, employers of a certain size required to provide sick and family leave wages. To provide some support for that, the government has provided a tax credit and what's called a refundable tax credit for those payments. So for instance, were some of I think they showed us on a prior slide, I think that the available sick leave, depending upon the reason, caps out at per employee at either $2,000 total or $5,111. Available family leave emergency leave, it caps out at about $10,000 per employee total. But to the extent that these payments are made, their credit is available and it caps out at those amounts that covers the leave payment in the amount of the leave payment, including any related or associated costs for health programs, for health plans, and also to cover the employer's associated Medicare tax. And I think that these payments are not going to be subject to the employer side Social Security. What's interesting about these payments, or rather these tax credits, is, for instance, these amounts, for instance, the leave payments are subject to taxation, so they'd be reportable, and normally it would be subject to employment tax and federal income tax withholding. The employer has a responsibility for withholding and also employer tax. The employer can apply these tax credits against its employment tax liability. And to the extent that there's any left over, the employer can even then apply for a refund, so actual cash. So if there aren't other tax liabilities out there, it's even possible for someone to get cash back or cash that can fund some of these required payments to its employees. There's an IRS form 7200 that someone would use in order to request a refund. But an example, for instance, is, let's say someone is entitled to a tax credit of $10,000, and let's say there is employment tax liability of $10,000, then they can anticipate that they'll be able to apply this credit and therefore won't have to pay in. Double check that before you do that, because penalties are can be, so make sure you get this right. But that's normally what has been provided. But again, always double check with your provider. And I'll finish my sentence. Let's say you owe $8,000, but you're entitled to a credit of $10,000. You could then, not only would you be able to apply this credit, but then you'd also request $2,000 back. Yes, Lourdes.
For an individual during this time, would you advise, as a tax professional, that they go on an exempt status with their unemployment or their family leave payments that they're receiving, so that they now can get more, as opposed to having it, taken out and then applying for a refund later?
You said for an individual, do I recommend that they go on exempt status so that so these are employer tax credits and they won't be going to the employee.
Right, no, I understand that. I'm talking about as an individual who's receiving these benefits, would you advise them to go exempt?
No, not necessarily. I mean, I think that, you have to kind of look at what you think your total dollars are going to be down the line. So yeah, if total numbers are lower, that may work, but, ultimately you have to figure out whether you have other sources of income or any other reason where you're going to owe down the line. It's just a plan.
Lourdes, one of the things about that is when they're determining a non-exempt employee's rate of pay, they look at the average, including overtime. So they look at what was that amount that was earned. So if somebody goes exempt, which they may not be able to classify themselves that way. Jeff could spend an hour talking about misclassification. I hear it in the back of his head. But they might deprive themselves of some overtime.
This is going to be an important issue coming up as we reopen.
So Levon, one of the things that as a business owner who got PPP, and also have some people who may go out on leave, I can get a tax credit for paying them for the leave. But if I'm paying with the PPP, does anybody figure that one out yet? Because I'm seeing a cautious loophole.
You know what? It's funny because as far as I can tell now, later we'll talk about the employer retention credit where you can't use if you get PPP, but I haven't seen anything that disqualifies you from getting a credit for the required payments for wage and family leave, even if you get the PPP. I have not seen that disqualification.
So there's some things that are prohibited throughout these programs that are important for both employees and employers to know. An employer can't force an employee to use their existing sick leave balance. They can allow employees to supplement with their sick leave, but they're not required. And they can't force somebody to locate their replacement. So like if someone can't work in a restaurant, they can't say you got to find someone to cover your shift. And just like you have with other Medical Leave Act protections, there can't be any retaliation or discrimination for anybody who takes the leave, files a complaint, makes a claim, or testifies in front of any organization or any agency. And people are supposed to be returned to their same or similar jobs, so they can't be demoted because they took some time off because of COVID. So a failure of an employee to pay this has the same penalties as the failure to pay minimum wages. And then there are penalties you can see here for fines with liquidated damages, reinstatement, attorney's fees, injunctive relief, and then where I come in. There can be the payment of attorney's fees for a plaintiff's lawyer like myself who is seeking to balance the scales after someone has been retaliated against. So there is a good comparison, a side-by-side comparison of the COVID paid leave and the California sick leave at the Department of Industrial Relations. You'll be given this PowerPoint with that URL so that you can go and see that. It's a really good chart that we used in our preparation. Jeff, do you want to talk about these next two slides available for people?
There's this particular slide refers to a grid that was put together by the Labor and Workforce Development Agency, which is best known as the agency through which employees need to exhaust their remedies before filing a PAGA action, a Private Attorney General's Act action. But they've, I believe included with the materials is a nice grid that they've put together that does discuss some of the resources that are available by different benefits. For example, disability insurance, if you're unable to work due to a medical quarantine or illness related to COVID-19, certified by a medical professional, what type of benefit is available and how long it lasts and so forth. And I see we're also just moving on to this slide. What's on the screen right now is the poster that employers need to be posting as part of the FFCRA to let folks know about their rights. Some of these rights are, listed here in a quick, hopefully accessible manner. There's some excellent resources, and I don't know that we need to get into all the weeds, but as we're reopening, it's great that in contrast with the end of March, we now have at least some guidance, a roadmap of what we need to do, and to avoid some of the pitfalls that Chris has touched on. One other one, by the way, that I think is worth mentioning. I don't know where this might be on the slide, and I think it might fit in here someplace, but is the business reimbursement, the business expense reimbursement requirement, Chris. Is this the time for that, or is that in a different place in our presentation?
I think we'll put it in later on. You've got an interesting slide that talks about 2802.
Okay, very good. Okay.
So Levon is now going to talk to us a little bit about some of the programs that are being available for employers and the tax issues that relate to them.
Sure. And I wanted to jump back for a minute because I remember there was one thing that I kind of skipped over when I talked about the credits for available for sick and family leave. One thing that I should note, I indicated that it's includable in income to the employee. What I should also note is actually it's also, the credits are includable in income to the employer as well. But the employer is, of course, going to be getting the deduction for the payment to the employee. So it's almost as if they're requiring you to make these payments, but they're giving you kind of income to do so, to some extent. So with respect to that, then we come to the CARES Act, and there's some other provisions for relief. And I wanted to note also that to some extent, as far as the tax stuff, this is an overview. Next week, Thursday on June 4th, where there will be actually an in-depth discussion at the Bar Association regarding the tax implications or dealing with the Paycheck Protection Program. But under CARES, there's several relief programs. And before I get to Paycheck Protection Program, I want to comment on a couple that are important. One is simply the ability to defer employer-side Social Security. So any employer can do this. Been given the opportunity to defer the employer portion of Social Security payments. Basically, I have to check, but I think it's like April 1 through December 31. And those would be then due half by or before December 31, 2021, and half by or before December 31, 2022. Another provision that's made available is the employee retention credit. So again, this is really an attempt to try to, we have the unemployment side, but then also there's a hope that they can keep employees on the books and not send them into unemployment. And that's the purpose of things like the Payroll Protection Program, which I know that Jeff and Chris will talk about kind of some of the difficulties of that in terms of if you have business in trouble, just providing the payroll, but not helping much on the other side. But there's an employee retention credit, which is available for qualifying employers. And typically employers have had to suspend their business or where their gross receipts have been substantially impaired. And there are definitions with respect to what those mean. But typically if you have that, then you could receive credits for up to $5,000 per employee. This is made on a quarter by quarter determination this year, but there is available credits of up to $5,000 per employee. These are also refundable tax credits. For some people, this is going to be very helpful. Something that I want to note how these relate, both of these, to the Payroll Protection Program. With the employee retention credit, if an employer does receive funds through the Payroll Protection Program, then they cannot use the employee retention credit. But with respect to the deferral, going back to the other issue of deferring the employer portion of the Social Security payment, and an employer can do so until they receive notice from their lender that the PPP loan that they received has been forgiven. So again, if you're deferring employer Social Security, you can do so until you receive notice that your PPP loan is forgiven. With respect to, and now jumping back once again to the employer retention credit, one other thing is how is that treated for tax purposes? The payments that the employee receives against the employees receiving compensation, so it's includable in their income. What's kind of interesting is that the employer retention credit, if someone receives that, they do not include, like the employer does not include that payment in income, but they also don't get deduction for the related payments to the employee, which sounds kind of similar to the results from Paycheck Protection Program that we'll roll into now. So pretty much everyone is aware of the Paycheck Protection Program. And Jeff has been kind enough to put wonderful comparisons. These are both SBA programs. The Paycheck Protection Program is available through the SBA, but basically the loans are made through qualifying lenders. versus the economic injury disaster loan is made directly from the SBA. So one thing is the difference is who can receive these. The Paycheck Protection Program is available to private employers. It's also available to 501c3s. The economic injury disaster loan is a little bit of a wider net, so it's also available to others, say, for instance, C6s and associations. What's been exciting about the Paycheck Protection Program is the thought process that this is actually a forgivable loan. And so this is a program where the amount can be forgiven, but one has to go through some certain steps to make sure that happens. So within 10 days of being notified that one qualifies to get the loan, it should be funded. From that point, they have 8 weeks to use the monies, and then they would basically apply. There's another application to apply for forgiveness. The way this works is that you can only use the monies under the Paycheck Protection Program. You can only use the monies for certain purposes. That would be for payroll costs and related costs, and then also payments for mortgage interest for real and personal property loans, and then also utilities, and also rent or lease payments under a business rental or lease agreement. And in order for the loan to be forgivable, 75% of that would have had to been made for payroll payments. So obviously there's kind of some implications for people who may need the funds more for rent. But in order for it to be forgivable, it has to be used in a certain way. And what we'll discuss kind of in the tax program that comes out, but there is an application out there, and there's kind of some math involved in terms of determining whether you meet the threshold. If the loan is not forgiven, then you end up, or if you have a portion that's portion that's unforgiven, then you end up with a loan at 1%. The initial payment is deferred 6 months from the loan date. Let's see, with respect to how these are treated, what the forgivable portion means that if you are forgiven a loan, you have cancellation of indebtedness income, but it's not taxed as such on federal level. My understanding is that California would tax it, and so far. Now, but if at the federal level, if it's forgiven, then you're not good. So far, the IRS has come out with guidance that says that you will not get to deduct your related expenses. This is because this is being addressed at tax-exempt income, and normally you don't get a deduction for with respect to expenses related to tax-exempt income. But it's understood that legislators, they meant something different, so that could change. I suspect that there's some legislation out there. California, I'm not aware that California is forgiving these amounts right now. So if there is an amount, or rather it's not taxing these forgiven amounts. So if they tax it, presumably there would be a deduction available under California. As opposed to the EIDL loan is going to be different, because that really is a loan payable over a period of 30 years. 3.75% interest for small employers, 2.75% interest for nonprofits, and but there is an advance that's available up to $1,000 per employee that is considered a grant under that particular loan. So those are kind of the broad general provisions. If people have specific questions, they can let me know.
So
Jeff?
The next thing we're going to talk about is what a lot of us have been doing, which is teleworking and telecommuting. We've all sort of just slipped into this, and we're all doing it right now, but there are things that we have to be aware of that don't usually fall in the outside the office environment. Under California law, there's a requirement to pay workers' compensation. If someone's in their home and they are moving their monitor and they blow out their back, then I'm on the hook for the workers' comp. Interestingly enough, if they are going to the store to get something for their printer, I'm on the hook for workers' comp if they get hurt, and I might get sued because they could be in the course and scope of their employment. Under California law, I'm required to make sure that my employees are getting paid for all the hours that they work. So I have to have a program and a policy that relates to tracking time and breaks and meal times that can be tracked so people aren't deprived of what they're entitled to, and that you as an employer don't get sued for failure to provide meals and rest breaks. Now, I'm on both sides of this coin as an employer and employer, so I'm especially sensitive to it. And then the final thing is under California law, an employer has an obligation to provide, as part of their illness and injury prevention plan, an ergonomically appropriate work environment. And that could lead to, if this is prolonged, employers having the rights to have someone come into your house and take a look at your workstation, and a requirement that you be given ergonomic workstations, or someone be given an ergonomic workstation to meet that requirement. The other thing that comes up is, confidentiality. We have an obligation to provide for our client confidences under Rule 3-100 in Business and Professions Code, Section 608. We have to keep those confidences inviolate. Additionally, we've got issues when people are working off-site that have to do with data privacy. And there have been included in the materials this opinion order as it relates to data privacy and what to happen if somebody has a breach while they're out of the office. So as far as confidentiality goes, they have to be passwords. We use two-factor authentication. Biometrics are often used to make sure it's only the person who is the right to have that access. You've got to make sure you have the right firewalls, the right malware protection, and your employees have to be trained on how not to click on the inviting item that could demo your entire computer system. So under the formal opinion, you have to monitor for data breaches. If you detect a breach, you have to stop and mitigate, and you have to investigate. It's all under a reasonable standard. It's not strict liability. And additionally, under Rule 1.4 in BMP 6068, you have an obligation to keep clients informed. So if their data has been breached, lost, a computer stolen, you have to advise them of the fact that there has been some material that's taken. It's a significant development. You can tell them about your encryption programs and how it's probably safe, but you can't conceal it from an employer. So it's a client. It's very important that your employees are aware of the importance of confidentiality and data privacy throughout this time. So Jeff, this is your slide as it relates to indemnity. And that is that you out there, or is, on the rack?
No, that guy looks a lot more relaxed and comfortable than I am when I'm working. But just before I get on to the Labor Code 2802 provision, I think I'd like to highlight some of what you said, Chris, about privacy, because it's really an important consideration. And it ties in some of the interim guidance from Cal OSHA in terms of protecting workers from COVID-19. There's some things that employers really need to be doing, which touches on privacy, pre-screening measures, taking employees' temperatures, asking about travel, regular monitoring, and the questions that really need to be asked is who's taking this information on behalf of the employer? How is it being kept? Is it being kept confidential? And not to make things overly complicated, but this can also tie together with the new California Consumer Privacy Act, the CCPA, which has certain provisions that, as they relate to employers, are going to be going into effect January 1st, except for a couple that relate to having reasonable security measures to safeguard data that's collected and disclosure of the categories of personal information. So there's a lot to that. What you talked about is so important as we go to the opening, to balance the privacy issues against what we need to be doing to keep everyone safe and to keep businesses functioning. But getting back to the slide of the guy who's not me, but that's my mental state when I'm working. So in any event, California is somewhat unusual in that it does have a statutory obligation for employers to reimburse their employees for reasonable business expenses. And now that more people are going to be telecommuting, and now that we're restarting with people potentially working from home more often, there's a whole lot to think about. You know, not just the cell phone, which is the traditional thing that businesses might reimburse for if it's required, but also printers, computer use, internet use. And there's not all that much litigation or guidance in this area. It's you know, there can be an actual expense type of accounting for this. There can be estimates, and it's going to be important, just as an issue to be aware of, to be cognizant that to the extent that the employees are working remotely, using their own devices, their own homes, their own whatever it might be, that a requirement under Labor Code 2802 for reimbursement of these reasonable business expenses might create some liability or obligations there.
Well, Levon, tell us about what tax benefits or that people working from home can now make as part of their tax deductions because they are working from home, using their own equipment, using a dedicated room for business.
Well, and so I think, you know, my understanding is I don't think that the rules surrounding the home office deduction have changed at all. So to the extent that, so one, there's going to be an issue with respect to the space that you use and being able to account for that and make sure that that's only used for your home office. And then after that, I think that to the extent that people are, you know, purchasing printers and computers and having to pay for enhanced internet and all of that, it would say all of that, those are going to come under, let me think about, actually, these are certain expenses are going to be employee business expenses, which are currently not going to be deductible. That's a really excellent question. But I think for the home office deduction in terms of kind of that space for your office, there's nothing about the CARES Act that has changed at all.
So that was a question I had, and I threw this slide in here as a loop for you. Sorry about that. But I have an office that's downtown San Francisco, one in Los Angeles, and one in Oakland. Now, because of the proximity of my residence to an office that I have in San Francisco, I'm generally not allowed to declare my home office because it's more for my convenience, they say, than it is for my actual business need. But that's changed during these last months because I'm not allowed to go to my office. And this is my only office. Do you think that, I mean, I won't hold you to it, but do you think that there's an argument that for the time that I have been sheltered in place and prohibited from going to my office, that I can make a tax deduction claim for my my home and my green screen?
You know what? I think that there is an argument now for that, certainly. So I'm just kind of comparing that to, you know, employee business expenses are kind of off the table under the prior, you know, until 2025. So I was trying to think about where you would take that. But to the extent that you would normally get a home office deduction, then where that's been precluded because you were too close to your office since you can't go there, I think that's an excellent argument that you can make if that's what precluded you. What I would just do is put a disclosure on the return, let them know that that's the position I was taking.
So one of the things I want to talk about is that it's going to be very hard for businesses to say, gee, I can't really let you work from home. That's what we've all been doing. So it'll come up in a moment when we talk about how reopening and what we have to do for flexibility. I think it would have been far easier for employers beforehand when looking at accommodations, when looking at teleworking, to say, you know what, we really need the lawyers here, hands on deck, team approach. It's very difficult to put together a trial team if we're not all in the same place at the same time, which I try 4 or 5 cases a year, and Lourdes and I tried one right before this all went down. We had patient 0 on the stand, a cop with a cold, and he got sick, and it went to the court reporter, and then it went over to the jury, and it swept through the jury box, and then it went to the judge, and then it went to the bailiff, and it went to the defense attorneys, and it came to Lourdes, and I'm like, I got to get my closing. I got to get out of here. I brought in big bottles of sanitizer, put them all over the room, and I was the only guy who didn't get sick in the room. So I don't know if they built antibiotics, but we were in Alhambra, and it was December. And so there were a lot of flights going in and out of LA, and Alhambra is a large Asian population. And so it wasn't uncommon for people to wear masks, but I couldn't give a closing argument in a mask. But we were at the cusp of this whole crisis, and we're really towards the tail end of trials that were happening. So Lourdes?
Well, now the governor just announced today that we're entering into stage 3, which allows the reopening of higher risk workplaces that require close proximity to people, including hair salons, gyms, nail salons, movie theaters, sporting events without live audiences, in-person religious services. So we've now moved, at least as of today, from stage 2 to stage 3. That is all contingent upon, of course, what each local mayor has determined.
Okay, so it 2:00 in the morning when I was putting these slides together, Gavin hadn't made it stage 3, and during my last 6 hours of deposition, I didn't get that memo. So, but we all fall under stage 2 anyway. So why don't you take it away regarding stage 2?
Well, stage 2 is, not, as we know, non-essential manufacturing, schools, childcare facilities, retail businesses for curbside pickup, and offices that aren't working remote, where working remotely is impossible. And it can be modified to make the environment safer for employees. So that's where we are currently up until the announcement at noon today by Gavin Newsom. We have not heard, at least here in Los Angeles, from Garcetti on whether or not we are moving into stage 2. We have been slower than the state proclamation. I don't know, San Francisco, where you all are going to be at.
We're in stage 2, heading towards stage 3 here. And it's interesting because I have in workplaces in 3 different counties where we're monitoring them all. But so we're figuring out, will some people return in some counties before others? And we'll talk in a moment about what an employer needs to do to make these decisions. But I think that we're kind of on the new frontier here, and this next part of our program is going to help you to understand some of how to deal with getting back into the world. So Jeff is going to talk about if your employees are coming back at a different pay rate or a different schedule and what you have to do.
Yeah, so this opens a whole plethora of different issues. Wage and hour issues are embedded throughout this pandemic and reopening efforts. Obviously, one of many things that employers need to consider is renewing the WTPA notice, which is basically a requirement to provide certain information to employees regarding their rate of pay and other things. As we touched on, here's an example of the form that the state provides. Employers do not need to use this form particularly, but many do.
We provided this in the materials for everybody, so they'll have a copy to use in the future.
Yeah, and it can be, it's good to consult with counsel to see if you want to make any modification to this as to some of the extra information that may or may not be required. But it's an example of what you have to think about. And in the same way, as people are coming in maybe on different hours, there are reporting time pay requirements in California that need to be adhered to. And as we touched on earlier, for exempt employees, to the extent that these exempt employees might be taking a hit to their salary and then falling below the salary threshold for an exempt classification, that could be a problem. And coupled with that is if these exempt employees now are coming in and filling in for non-exempt employees, employers have to be real careful about the duties test in California. If you're not it's a 50% threshold. If you need to be doing that amount of exempt duties to qualify for the exemption. It's a numeric calculation in California. So these are things that, as we reopen, there are so many different areas of law to be aware of. And as we mentioned earlier, even not giving the paid sick time, Chris mentioned, that can give rise to a wage claim. It can, which can trigger, again, the PAGA litigation. There's a lot of good guidance in here. The DLSC has put together some guidance, which I believe is in the handout materials. The labor commissioner, essentially, that covers some of the wage and hour issues that might arise as we try to get up and running again, or reopen, or accomplish something a little closer to whatever normal might be.
So Jeff, let's talk about returning into the workplace now, shifting gears as it relates to protection and employee rights. A lot of those questions that we have out there about what employers have to do before they can bring people back to work.
Yeah, well, one provision of California law always has been that employers need to have a injury and illness prevention program, an IIPP, and there's nothing new about it. But now it's so much more important and so much more in the spotlight, arguably. Because of the pandemic. And in fact, the interim guidance, the interim general guidelines from Cal OSHA really touch on some of what needs to be part of that. There are tools available. There are a lot of resources to help employers go through it. And some of the bullet points now appearing on the screen include things to consider. Perform a detailed risk assessment, and then implement a site-specific IIPP. Make sure that's posted, by the way. The IIPP needs to be posted. Train employees how to limit the spread of COVID-19. Implement the control measures and screening. Again, touching on privacy issues. These all interact with each other. Some of the things that need to be included in an IIP might be encouraging sick employees to stay at home, immediately sending employees home if they have some kind of symptoms. If you need if anyone needs additional guidance on this, here. This is the slide which references the some of the materials that we've been discussing.
So this is the Department of Labor's, which is actually put together with the Department of Health and Human Services. It's more detailed than the one that's put together by California, but this is the current Cal OSHA, Department of Public Health for California Industry Guidance Manual for office spaces that we're going to morph into next. But this, I think, Jeff, would you agree with me that if you follow these steps and you document them, and we'll show people how they can easily document it because it has to be a written program, that they will meet their obligations. So, for example, Jeff was talking about a worksite specific plan. And here are the items that the government says need to be in it. You have to have health department notification. You have to train people on the plan, evaluate the plan, investigate the COVID-19 illness. Well, this becomes tricky that you're going to see later on as it relates to questions and answers given by the Fair Employment and Housing Act. And then we need to keep track of who they've been in contact with. And that is something that in your plan, you can help control by when people return to work, having distinct locations. I mean, we're going to be filling empty office space that we have with some of our staff that wouldn't get offices. We have a very large conference center that we're going to partition out with some desks in it more than 6 feet apart. And we're going to have a rotating work plan for our Los Angeles office until we move to bigger space, because except for the people who are in offices, there are 4 employees who sit out for general assistance, and 3 of them, even though we have partitions, we're trying to figure out, will they be 8 feet apart? So employee training, you have to train your employees on how to prevent, how to screen, and how not to come to work. Many of these programs we were talking about earlier as we said, were to prevent people from having to choose between their job and their ability to take care of themselves, because you don't want to pressure people to come to work for money if they're going to wipe out your workplace. And then to even, how many times have we heard it, but we're going to put up signs regarding wash your hands. In my office, we provided, before this happened, we provided everybody with a big old bottle of hand sanitizer. We bought wipes. We had a wipe down process by which all of the doors were wiped every hour. The copiers, we have clean wipes next to them. So you have to train people about face coverings, and anybody who's in there as a temp, you have to let know too. So this is what Jeff was talking about regarding screenings. So I doubt anybody's ever been in the position of giving a medical exam to an employee before they came into work. But, temperature checks now, you're going to be allowed to take them as an employer. For our 3 offices, I purchased 24-inch screens that have thermal imaging capabilities. So as someone enters the office, they walk by a screen that will sound an alarm if their temperature is over 99.3 or 99.5. And we're having those installed. It's not cheap. It's about $1,500 a unit. And if they go off, we're going to have a thing on the side where they're going to pick up a piece of paper that says, you got to go home if you work for us, or if you're a client, we'll be happy to assist you over Zoom. So,
Chris, I have a question. Should hourly non-exempt employees be compensated for their time during the health screening?
During what? Health screening?
If
I think
an
so. It's
employer
like,
is requiring.
yeah, it's donning and doffing in my opinion. I mean, you're telling them line up and get screened. In my opinion, though, Jeff may look at it differently from the employment side. I think at that point they've reported for work and they're going through work-required screening.
Yeah, I mean, go ahead.
No, go ahead.
Well, I was going to say,
I have a couple of questions on this.
Yeah, for employers, it's at this time amid reopening, the last thing I think employers want to do is create potential liability exposure to the extent that these employees are under the control of their employer when they're being screened. It's probably best to do it on the clock, but each employer really should, the circumstances are going to be different from one to the next. Each employer should really discuss this with their employment counsel to make sure that they're doing what is required, and consistent with what needs to be done as we reopen.
Now,
with their
what if an
employment
employee
counsel.
refuses?
Go ahead, Lourdes, apologize.
So what if an employee refuses to consent to a health testing? What do you do?
I'm going to send you home, Lourdes, if you don't want to do it. You're going to have to pack up your bags and go back and work right in that spot where you've become glued. And I believe I have the right and I have the obligation in providing a safe workplace to not allow people who won't be tested, which I'm allowed to do, to go home. I can't penalize them per se, but I could, if they can telework, I can send them home. Or ultimately, I believe that they might be disconnected from service, which is a nice word, for a refusal to engage in safety measures. What's your thought on that?
If there is a requirement for employees to submit to some kind of testing and monitoring that's called for under these COVID-19 provisions, and the employee is showing up and not doing that, they're essentially not showing up ready for work. Again, it's a developing area of law, and it'll be interesting to see what types of claims might arise out of this type of scenario. But it makes perfect sense to me that as an employer, and under these guidelines that we've been discussing, the key is on keeping the workplaces safe, healthy, and doing so within the context of protecting privacy and reopening in a manner that allows it to be successful. those are my general thoughts.
I think the big question, the big unknown is what happens when a vaccine comes out.
That was my next question. Can employers require an employee to be vaccinated?
Let's hope to God that somebody comes out with a guidance on that one, because that gets into all sorts of issues of medical privacy. I'm pretty sure that a government will allow some guidance so people can make these decisions, because they're going to be doing it for schools. I know that much, I'm pretty sure. And whether or not there will be exemptions for people who are, I don't want to use the pejorative term, but people who are, who choose to opt out of inoculations, it will be interesting to see what will happen. I'm sure that'll be a matter of legislation.
Do you think there'll be any pressure on employers to, for instance, what if an employee says that they can do their job just as well at home? So why should they have to be subject to some of these requirements?
Well, I think if so here's, we're now getting off. Is it a religious-based thing? Would that potentially be based upon religion? And if your requirement is that they work there, would they have a right to some sort of religious accommodation? I mean, a true religious accommodation? Is it something that they're sensitive to items that might be in the vaccine, like they've had bad reactions in the past to flu vaccine? Then I think that they would be given an accommodation potentially of that, if that would be the case. So it's going to be kind of a shifting environment. What is the reason why? If it's merely just, I don't like vaccines, I don't know if that's tied to a protected classification. It might be tied to medical privacy as to whether or not they have to tell you. But the way things are going right now, it appears that disclosure is going to be something that employers are going to be able to ask. But I think that's going to be a matter of substantive law or regulation that's going to have to develop.
And to the extent that it ties in with some kind of medical need or medical condition, one thing that a lot of employers sometimes don't immediately think about is the requirement at the end of a leave period, or if some medical disability exists, to proactively engage in an interactive process with the employee before making some kind of termination decision to find out if a reasonable accommodation might help them keep their job. And what we're talking about then is really a reasonable accommodation. Not all accommodations are reasonable, but I think it's worth mentioning just that interactive process requirement that sometimes gets left out of the equation.
So will you be able to require your employees to wear masks? We're going to learn about that in just a second as we come towards the end of our program. But your illness prevention program, you need to have a protocol for cleaning. Interestingly enough, we had this before we left, right, Lourdes? I mean, I kind of put this in place 2 weeks before we went down. But you have to have cleaning. And here's another thing about implementing cleaning practices. I think you'd have to pay someone who shows up in the morning and wants to use a Clorox wipe on their computer, their desktop, their keyboard, because they have to be given that time. And then the other thing that you think about is elevators. Our office in Los Angeles is in a penthouse at the Wedbush building. And I've been there in the morning when we're going in, and the elevators have 10 people in them. I did go to the office on Friday because I had to pick up some material in Los Angeles, and they had 4 dots on each of the corners of the elevator for social distancing, where they're going to limit the number of people to 4 per an elevator. So you might want to think about staggering people's start times. I know Lourdes likes to get in early. Amy Kirby, who works for me, comes in at like 6:30 in the morning. But I think we're going to have to be flexible, allowing people to come in earlier or later. And we'll probably be doing alternating work from home as well. But don't have people passing around phones. I mean, copiers are going to have to get wiped down regularly. And that the bathrooms have plenty of soap, because you got to be out there doing the Fauci hand scrub if you want to make sure your employees don't go out on unemployment. So this next phase of the program, and we're kind of going to talk about, is here's information on physical distancing guidelines. We talked a little bit about that. We're instituting a barrier for our receptionist. He will have a plexiglass screen in front of him when he returns, and at all 3 of our locations, the people who are handling reception will then be having that kind of protection. So these items are in here about staggering breaks. We're shutting down our break room because it's a congregation point, and we're closing the kitchen, closing the break room. We have a gym facility in our San Francisco office. We're closing the gym simply because those are areas that people might congregate and potentially create a risk to them. And then, you know, when people come into the office, you want to get them to a conference room right away. You don't want them sitting around in the lobby where they might affect other people. And so that's all. So, Lourdes, why don't you bring us into the next section here about what we're going to talk about in the final minutes that we have.
Well, we're going to be talking about things you can do and cannot do as far as employers.
So, go ahead.
Well, can you send an employee home if they display symptoms?
And Jeff, your answer would be for 500?
Yeah. Yeah, I mean, if the employee is displaying symptoms of COVID-19 illness, a dry cough, or expresses that they have a fever, whatever it might be, this is part of your injury and illness protection plan.
Well, what if they test positive for COVID-19 but have no symptoms?
Ah, now you're getting into a tricky area that we'll talk about on the next slide. So, Levon, during a pandemic, what can you ask about people who are feeling ill?
During a pandemic, I guess you can ask them if they have such symptoms such as chills, cough, sore throat, and employers must maintain all information about this as a confidential medical record.
This is a pretty significant departure of what's out there. I mean, if you saw somebody getting sick in the morning, you couldn't ask them, hey, are you pregnant? But you can ask them about whether or not they're suffering from a pandemic-related disease.
Right.
And then about temperature taking. Yeah, you're allowed to take temperatures, and indeed, as part of the IIPP, they're recommending that you do so. So, okay, Lourdes, go ahead and ask the question.
What if they've tested positive but have no symptoms? Can you force them to stay at home?
You betcha. But you have to pay them for sick leave, and then you can ask them to get some sort of certification that they're okay to come back to work. You can't do it pejoratively, but I think if somebody's coming in and they're sweating and their eyes are red and they don't smell like booze, and they hit your temperature check that goes off, I think you can say, I'm sorry, I need you to go home. And then if you can get cleared by a doctor, and you may remember we had an employee in Los Angeles who made us all very nervous because she was hacking a lung during the few weeks right before we left. And I did send her home, and I did ask her to go to a doctor, and I did pay her, and she did come back with a note saying it was because of her smoking and not because of COVID. You remember that?
Yep. Now, for Jeff and Chris, what do you do if you have an employee that you don't have any issues of COVID-19 in your workplace? You've done what you can to make it as safe as possible, but they're too scared to come into work. Do you have to accommodate them?
Jeff? Let me go. So here's where it gets tricky. Do they have a diagnosed anxiety disorder?
No, well, so one thing that makes it a little simple is that under the, nothing is simple, but under the state's ordinary paid sick leave laws, it's really the employee who decides what constitutes a need for paid sick leave. I mean, there are qualified reasons, and if that you're supposed to use for paid sick leave, but it's, you know, if the employee decides I need a sick day because I'm afraid to come into work, then at least under the paid sick leave law, it seems like that's one mechanism for them to have protected leave.
So
let me take it a But further, we have all been working remotely. What if they want to continue working remotely because they're too scared to come to the office? They want to do their job. They can't.
Lourdes, you trying to back me into a corner here on TV because you got something you want to talk to me about later on, but
not at all.
What I would say is employees don't ultimately get to dictate the nature of their workplace. But if an employee has an anxiety disorder, an obsessive compulsive disorder, I have a client who we have a case now because before this happened, she was at a very high risk respiratory condition because of some prior lung cancer. And she told her employer, look, I need to go home. I can't be out on the floor doing retail because I'm at high risk. And the employer said, well, too bad, you've got to be out there. I told her, send in a note, go home. And they began to retaliate against her. So there was a reason. So if you have an anxiety disorder, you have asthma, you have diabetes, you have something that makes you concerned about taking public transportation to get to work, which is in our San Francisco and Oakland offices. I know in LA, you people don't walk anywhere and you don't take public transportation. So probably doesn't apply to you, but I mean, I think that they would have a reasonable, if they had a legitimate reason not to get on that BART for some period of time until we could work something else out. As you know, Lourdes, during the period that we had certain people coming in and I paid their parking so they wouldn't have to get on BART. So, you know, there are a couple of other pages on here that we will just show you, but we've gone past our time. So we want to provide any opportunity for questions later on that people may have, but you'll see here that we provided you some FAQs from the Department of Employment, whether they can require to wear PPE, yes. If I were the employer, I'd make sure that you provide it for them. Now, here's an interesting one. If an employee lets you know that they've been quarantined or have COVID, can you tell the other people at work? This is a real tricky one. And the answer is you're not supposed to reveal a way that reveals the personal health information. You have to notify affected employees. You could speak with employees and say, we've learned that an employee tested positive. You should go check with your health official or doctor. And it's somewhat absurd because, you know, if you're sitting next to Bill and Bill's suddenly sweating, coughing, and gone, you know, you can't say, yo, it's Bill, by the way, who had it. You can't even kind of wink and point. You just have to give the generic, this is what it's all about. So we've talked about reasonable accommodation and medical leave. Jeff asked me to talk about the issue of any type of anticipated litigation that might come up. And when I was thinking this over, this is the image that came to mind, because us plaintiff lawyers are always thinking of new ways to get a case started. But I think there are going to be issues relating to an employer's failure to institute safety protocol and that leading to a 132A claim and workers' comp for serious and willful. I think that employers that don't have the programs will probably be more susceptible to comp claims. I think we're going to see a number of what we call Labor Code 1102.5 violations where you have people who may be reporting that the employer's not in conformity with statute or does not have the right plans or isn't doing the right thing, and the employer lashes out and disciplines or fires someone. That's a whistleblowing statute that generically covers things. You're somewhat restricted from any type of claims directly for your personal injuries against your own employer because of workers' comp. But if you go to another law firm and they are not engaging in these responsible practices, and you get sick because the receptionist at the front has a sign on it that says, I have COVID, welcome, and coughs on you, I think you got a negligence action. And it's going to be interesting to see, as we saw in other virus issues like with AIDS, herpes, whether someone who knows they're infected, who does not tell someone else, and we see this a lot in relationships or romantic relationships and infects the other person, is there a battery claim? And I would have to say, yes, there is. So there are a number of things that I think that we can anticipate that are going to be arising out of this. So we've kind of gone over our time. We've talked a lot about what things are going to look like in the future. And the final slide was just, what's law like going to be in the future? You know, Levon, in your practice, how do you see this shaping your interactions with your clients and coworkers?
You know, and I think just like anyone else, I just think that there's going to be, as already, there's just going to be a lot more distant interactions. We'll see how all this shakes on the other side, but I just think that's, you know, this really is requiring of us all to be just more savvy technologically, and it's just moving everything forward years. What I think is also interesting, though, is that we're seeing various very large employers where they're allowing their people to telework, require teleworking until the end of the year. And I wonder if that sets any standard for other employers going down, you know, in the future, where people say, you know, I want to work from home, and that becomes a standard. But so we'll see. I guess my quick comment finally is that if we have, to the extent that people have to make expenditures on their offices, clearly there's going to be more expenses associated, but there's also, you may have to actually do, you know, improvements to your office. You were talking about expanding your space. Maybe they'll be moving walls, things like that. There are bonus depreciation rules that are in effect now that allow you to write those off. Take that as 100% depreciation in the first year. So just kind of throwing that in there.
So Jeff, how do you see your practice changing?
Well, I think similar to other business people or professionals, it's just amazing how much we had at our fingertips in terms of remote connections, Zoom, remote meetings. And, you know, I think that that's going to have an impact going forward in all workplaces. You know, some of the issues that you touched on as relates to working from home are going to be, I think, much more pronounced and important as employers consider how to navigate the coming landscape. You know, we organized this webinar, you know, online, and it's just amazing what we could do, and what we're all doing now, just without having offices necessarily or regular access to an office.
So some things that we're doing is I bought everybody in Los Angeles their own cup. And so that there were no communal cups, no communal coffee cups, no communal water cups. We have water dispensing stations. We're going to close them down because somebody could put their cup underneath the spigot and get it infected. So we're going to go back to what we tried to get away from, which is bottled water. So everybody has an individual bottle of water. I think it's going to dramatically impact our environment because as plaintiff lawyers, we're a tribe of renegades, and we get energy from each other. And as a trial lawyer, I work very closely with the trial teams and the lawyers who I try cases with. And we're up all night long. We're looking over documents together. Social distancing is going to be challenging, I think, in terms of not only the camaraderie, but the pace at which we'll be able to do things. And I will tell you that behind me is the thing I fear most, an empty courtroom, because this is my home, this is my workplace, and that's what's going on right now, and we don't have any idea as to how they're going to do jury trials, jury selection, we're not even getting remote hearings in some jurisdictions at all, so it's creating a difficulty. We're doing Zoom mediations, Zoom depositions. I've been involved in a lot of those. And I will just leave you with one final thought, which is that this is something that is not the first instance in which California has faced how to hold court during a pandemic. This is San Francisco in 1918, where they're holding court outdoors. And so they were a little bit more innovative back then than they are today, because the judges seem to have just folded up their tent for a while to get it all figured out. And because we're a system of courts that have individual counties assigned to each one, its own superior court with its own fiefdom, there is no top-down management except in rare circumstances where the Chief Justice was empowered with the Judicial Council by the governor to enter into certain emergency regulations. And she did those as it related to not having to have a deposition officer present with the deponent, extending the statute of limitations throughout the period of COVID, electronic service, and encouraging people to use email and work with each other, and an encouragement, an advisory, but not an order, that the superior courts move towards electronic hearings and in electronic courtroom procedures. So that is the end of our program. The very last thing that, if anybody, we see still some there, thank you for staying, is are there any more questions that you would like to have directed to our panelists? Okay, I'm not seeing any questions. So I want to thank Lourdes for putting it together, and for Levon, and for Jeff, everybody who participated. It's been a pleasure getting to know you. One of the things that's affecting my practice is the ability to network and get to know people, and to enjoy events like this where you participate with someone and you walk away as friends. So I say that we're more than Facebook friends, we're Zoom friends.
To all my Zoom friends.
Thank you very much.
Thank you so much.